Hello, and welcome back to Chapter 11 in Healthcare Law and Ethics. We are completing our lecture series on the HIPAA privacy law today. We're picking up with Section 3 on page 254, starting with preemption, HIPAA versus state law. Now, the thing to remember is HIPAA is a federal law, and what preemption is, it says that when state and federal laws conflict, then you have to follow the federal law. Okay, so again, preemption does apply to the privacy rule because ideally, covered entities need to follow or comply with both state and federal laws, but it's not always possible. So when that happens, HIPAA in this case should be what that covered entity complies with. However, the federal privacy rule only provides that floor, the minimum, the bare minimum requirements. So it does not preempt or supersede a stricter state law. So if your state law is going to provide greater privacy protections or provide greater patient rights regarding their protected health information, or fulfill specific purposes enumerated in the law. So again, there's less stringent but serve purposes such as controlling regulated substances or preventing healthcare fraud and abuse, then they can follow the state law. Because again, remember, HIPAA is the bare minimum requirements that a covered entity and a business associate have to follow. So if your state law is more strict, then you can follow state law. But if your state law is not stricter, if HIPAA happens to be more strict, then HIPAA is what you have to follow. All right, moving over to administrative requirements. HIPAA privacy rule imposes administrative requirements that govern actual implementation of the rule. Among other mandates, the administrative requirements include policy and procedure development, designated personnel, training, and document retention. So we're going to outline each one of these things. The HIPAA privacy rule provides several important standards regarding administrative requirements, including 1, standards for policies and procedures, and then changes to policies and procedures, a designation of a privacy officer and a contact person to receive complaints, requirements for privacy training, mitigation of wrongful use and disclosure, requirements for establishing data safeguards, prohibition against retaliation and waiver, and requirements for documentation retention. All right, so let's talk about each one of these. So policies and procedures. Covered entity has to implement policies and procedures to ensure compliance with all standards, implementation specifications, and other requirements in the privacy rule. This includes conducting an ongoing review of privacy policies and procedures and ensuring that all policy changes are consistent with changes in the privacy and security regulations. Any regulatory changes that materially affect the covered entity's notice of privacy practices, including those introduced by HITECH, must be updated in the notice of privacy practices. Now, current topics that must be addressed include policies and procedures associated with your high-risk areas where PHI may be captured or stored, but not easily controlled by the covered entity. So we're talking about mobile devices such as your cell phones and your tablets, iPads, which may or may not be in the custody of the covered entity and the BA's workforce. And then you have things like social media. So we're talking Facebook, Twitter, Snapchat, Instagram. The use of camera phones by staff, patients, and visitors, and the use of body-worn cameras by law enforcement officers. So covered entities really don't have a lot of control over all of these because it's not necessarily in their possession. Me as an employee, I have my own personal cell phone. I can go pick up charts on the nursing unit and have my phone on me, and maybe I'm walking past a patient's room and I'm like, oh man, that looks funny, and I take a picture of it. Well, the covered entity can't control that. That just kind of happens. So you need to have some policies and procedures in place for if that happens, and then what should not happen, especially when it comes to your workforce. All right, let's move down to our designation of a privacy officer. So again, We have to designate an individual known as a privacy officer to be responsible for developing and implementing our privacy policies and procedures. Now, in addition to a privacy officer, they also have to designate a person as the responsible party for receiving complaints. This individual must be able to provide further information about matters covered by the entity's Notice of Privacy Practices. All right, then we have to have workforce training and development. Every member of the covered entity's workforce must be trained in PHI policies and procedures. New members must be trained within a reasonable period of time after joining the workforce. In addition, whenever material changes are made to policies and procedures regarding privacy, then you have to have additional workforce training. Under HITECH, there are heightened consequences for business associates that violate the privacy rule. Therefore, business associates should train their own workforce members. It says covered entities and business associates and now individual members of their workforces, now remember this is per HITECH, are subject to the privacy rule and the penalties that accompany violations. It's important for covered entities and business associates to document all steps that have been taken to ensure compliance to the extent possible by its workforce. Covered entities must maintain documentation showing that privacy training has occurred. Business associates should also ensure that training is documented. Although not required, a signed statement of training by each workforce member is highly helpful to document compliance. Now, let's drop down to mitigation. So remember, mitigation from health records is to lessen the impact, to make things kind of smaller. So the privacy rule requires covered entities to mitigate as much as possible harmful effects that result from the wrongful use and disclosure of PHI. Because mitigation requires the lessening of the effects of wrongful use and disclosure, it is contingent upon the covered entity to determine the possible courses of action. Although HITECH requires one type of mitigation, which is breach notification, we've already covered that one, there are other types that can assuage the individual, including one, the simplest of all, an apology. Second, disciplinary action against the responsible employee or employees. Repair of the process that resulted in the breach. Payment of a bill or a financial loss that resulted from the infraction. And then gestures of goodwill and good public relations, so awarding gift certificates, things like that. Now, mitigation may occur following discovery of a breach by the covered entity or business associate or subsequent to a complaint that an individual filed with the organization, the OCR, or both. Determining what constitutes a breach, as well as determining the appropriate mitigation, are steps that the organization must take, and it should be outlined in their policies and procedures. All right, dropping down to data safeguards. Covered entities are required to have in place appropriate administrative, technical, and physical safeguards to protect the privacy of PHI from either intentional or unintentional uses or disclosures that violate the rule. These safeguards must limit incidental uses and disclosures. They may also include shredding of paper documents containing PHI and limiting access to areas containing PHI through the use of devices such as keyboards, passcodes, or locks. All right, then we have retaliation and waiver. To ensure an individual's right to complain about privacy rules violations, covered entities are expressly prohibited from retaliation and waiver. First, covered entities cannot retaliate against anyone who exercises his or her rights under the privacy rule, assist in an investigation by the Department of Health and Human Services or other appropriate investigative authority, or opposes an act or practice to the person believed in violation. Now, further, individuals cannot be required to waive the rights they hold under the privacy rule in order to retain or obtain treatment, payment, or enrollment benefits eligibility. So what that's saying is a hospital can't make a patient sign a document saying that they waive their rights to complain to get treatment access. Okay, so the hospital can't say, well, if you want to come here and be treated by us, you can't complain about what we do. Your choice to come here, blah blah blah. That's illegal, highly illegal. So cannot do that. All right, last one, documentation and retention. So again, HIPAA standard is 6 years. They require that documents be maintained for 6 years. The 6-year time frame refers to the latter of the following. So either the date the document was created or the last effective date of the document. Okay? Relevant documents include policies and procedures, notice of privacy practices, complaint dispositions and other actions, activities and designations that have to be documented per the privacy rule requirements. So if the privacy rule requires it, your notice of privacy and your any policies and procedures or complaint dispositions, you have to keep those from the last the creation date if it's in effect, or the last effective date if it's a new document. If you've not had any changes, then the creation date. If you've had changes, the last effective date. All right, let's talk about enforcement of penalties. If we aren't complying with HIPAA, what happens to us? Well, first of all, HITECH introduced several notable changes to the enforcement and penalty provisions for HIPAA. Overall, there is a notable movement away from the collaborative approach, focusing on corrective action, to a more punitive stance. Now, so the OCR, we know, enforces the privacy rule. Okay? That's who we can complain to. If we're not complaining directly to the covered entity, we can complain to the Office of Civil Rights. So they enforce the privacy rule. So complaints that are filed with the OCR and includes an online complaint portal option. Although compliance with the privacy rule has historically been monitored through a complaint-driven process, HITECH requires the Department of Health and Human Services to conduct audits of your covered entities and business associates. So it's kind of very similar to state licensure organizations. All right, dropping down into that third paragraph there, HITECH grants state attorneys general the ability to bring civil action in federal district court on behalf of residents believed to have been negatively affected by a HIPAA violation. Further, whereas legal responsibility for HIPAA violations was previously limited just to covered entities, employees, or other individuals can now be individually prosecuted. So not only was it just a covered entity, now it can come down to a specific employee or an individual on the workforce that can be prosecuted. Civil and criminal penalties may also now apply to business associates. Further, a method for compensating individuals harmed under HIPAA and HITECH provisions was to be recommended to the Secretary of Health and Human Services, but that was pending. I'm not 100% sure what happened with that. We might want to look that up and see. Now, the final HIPAA enforcement rule contains provisions for compliance, investigations, civil monetary penalties, and procedures related to hearings. Now, as of April 24th, 2017, the OCR has signed nearly 50 resolution agreements with covered entities and business associates, which are settlements compelling them to perform obligations per the agreements and to submit reports to the Department of Health and Human Services for 3 years. Okay? If a resolution cannot be reached through compliance or corrective actions provided by a resolution agreement, then the OCR will resort to the civil monetary penalties, which are fines imposed on a covered entity or a business associate because of the HIPAA violation. Now, HITECH has increased civil monetary penalties based on levels or tiers of intent and neglect. The nature and extent of both the violation and the harm are used to determine the amount assessed within each range. And so currently, the penalties have a cap of $1.5 million for identical violations within each category. Now, we have 4 categories here. So first of all, we have the unknowing. We don't know it's happening, okay? So there's a $100,000 to $50,000 per violation for these unknowing violations. So the covered entity or business associate would not have known a violation was committed even with reasonable due diligence. So let's say they dotted all of their I's and they crossed all of their T's and there was still no way of them knowing that this violation was committed. Okay, that's an unknowing violation. So $100 to $50,000 per incident. Second level, this is reasonable cause and not willful neglect. Okay, they knew or would have known with reasonable diligence. Okay, so those violations are $1,000 to $50,000 per violation. That's our reasonable cause. So we would have known with reasonable diligence, but it's not willful neglect. We're not purposefully doing it. Okay. Now the third, this one is called willful neglect and corrected. Okay. So these violations are $10,000 to $50,000 per violation if due to willful neglect and corrected within 30 days of discovery. So we know we're doing something wrong. We know that it's just a part of our normal process to do something wrong, and we get called on it. If we correct it and we no longer do that incorrect policy or procedure or whatever it was that we were doing, if we correct that, then that's willful neglect corrected. Our penalty remains pretty low. Could be between $10,000 and $50,000. Now, the last one. This is willful neglect. We know we're doing wrong. We're doing wrong on purpose. We're going to continue to do wrong. And it's not corrected as required, then that's an automatic $50,000 or more penalty per violation. Okay? So unknowing violations, reasonable cause, not willful neglect and corrected, and then willful neglect, not corrected. Those are our 4 tiers. Okay, the OCR may choose to pursue corrective action without assessing penalties for unknowing violations, but penalties are mandatory in all of the other categories. These provisions differ greatly from pre-HITECH penalties that prohibited CMPs due to reasonable cause if correction occurred within 30 days of when the CE knew that they should have known of the violation. So HITECH really kind of changed the game here. They require the penalties now, even on the reasonable causes. All right, last little section here. We're getting into privacy advocacy. Now, as the privacy of patient information becomes more transparent to the public, privacy advocates have sprung up to support the patient privacy efforts and to strengthen public awareness. Other organizations also exist that more broadly address the issue of privacy, like American Health Information Management Association. Okay, so they're both proactive internally and externally. They educate their own members, which is us, and then they also work to change and shape public policy and federal law to further one of the profession's central values: protecting privacy of patient information. Now, AHIMA serves as an instrumental privacy advocate through the functions and entities, and you can see that up in figure 11.2 over on page 260. But they work with policy and government relations staff. They have collaborative relationships with key privacy stakeholders, credentials in privacy and security, so you can go get that CHPS credential. So they have a lot to do with privacy advocacy. All right, so let's check your understanding at the bottom of 259. Enforcement of the privacy rule will continue to operate exclusively on a complaint-based system. That is false. It's not strictly on a complaint-based system. Number 2, the privacy rule provides a floor or a minimum of privacy requirements. That is true. Number 3, breach notification is one type of mitigation under the privacy rule. That is true. We talked about that a couple of pages over, where we talked about another mitigation act. Could be just apology or disciplinary action, but the biggest and best known is our breach notification. Number 4, to simplify processes, individuals may be required to waive their rights under the privacy rule to obtain treatment or benefits eligibility. False. That is illegal. That's over on the next page, or 257, retaliation and waiver. Cannot do that. And the last one, under high tech, state attorney generals may bring civil actions in federal court on behalf of residents believed to have been negatively affected by a HIPAA violation. That is true. That's in that paragraph, that third paragraph on 258 that we started reading. It grants the state general attorneys or attorneys general the ability to bring civil actions in federal district court. All right, so that concludes chapter 11 and the privacy rule. So happy reading and happy studying there. Good luck on your test, and then we are going to get started on our very last chapter for healthcare law and ethics next week. Thanks, and have a great day.